Hello everyone. So this is the part 3 of the previous year paper. That is basically question number 3 of part A, right? That contains 3 questions, so that I will discuss here. Now one thing, people are messaging that where is this PDF of this that you can find, right? So I have already told you, right? The PDF you can find on that website defactolaw.in. okay, so there you can find separate PDF of each of the discussion, right? You can download, and the better you take a print out of it and keep it with you, okay? So that will be much better. Okay, so let us start with question number 3. It contains 3 questions, okay, sub parts. So let us start with 3A. It is question number 3 of paper 1. okay. Now the question number 3A says that examining the scope of protective discrimination offered to person belonging to scheduled caste and scheduled tribe and other backward classes under 15 and 16 of the Constitution of India, explained with the help of decided cases. Now you must be knowing that there are 3 equality principles that evolved, right? Initially it was reasonable classification, right? Then doctrine of arbitrariness, right? And then protective discrimination, right? Now what is the crux of protective discrimination? Let me explain you. Initially it was held that article 15 and 16, okay, is the only method by which you can violate article 14. It means if you want to violate article 14, you should be either covered under 15 or 16. Similarly, it was held that the subsections of 15 and 16 are basically exception to the to the rights provided under 15 and 16, right? So 15 says the state will not discriminate against you, right? And it says that it may discriminate. There are multiple grounds on which the discrimination can take place. It means clause 4 and 5 of 15 is an exception to clause 1 of 15. Similarly, same thing with the case of article 16, that clause 4 and 5 of article 16 is exception of clause 1 of article 16. okay. Now that viewpoint is very limited. okay. It means that, see, whatever the rights given under 15 and 16 will only subsist, right? I mean, the only way that you want to violate that right is by coming within the exceptions, right? It means there must be a reasonable, there must be, your criteria for classification must come under those exceptions. okay. Now that thing was put down and said that no, the state might come up with their new way of discrimination not covered within the exceptions of 15 and 16, right? So indirectly the court is saying that 15 and 16 clauses are not exceptions to the sub clauses. okay. Sub clauses are not exceptions to other sub clauses. okay. Now that became a very important doctrine called discriminative protective discrimination. okay. So the reasonable classification went into the second part, that is your doctrine of arbitrariness, and then we came to this doctrine that is your reasonable classification, right? Now in the case of reasonable classification, you must have seen in the presence of a intelligible differentia and their relationship with the purpose of the differentiation. Similarly, in the arbitrariness, right, violates the rules of natural justice. Then this protective discrimination basically means that you are discriminating, right? So it seems to be discriminatory, but it is in order to achieve a larger equality. okay. So you are basically discriminating not to increase inequality but to increase equality. okay. That is the crux of protective discrimination, right? So that is what you will explain here. okay. The meaning of protective discrimination, right? It have its root in the equal protection of law actually, and then you will explain the constitutional provision, right? It means you will explain article 15.3, 15.3, 15.5, right? That provides for protective discrimination. Similarly 16.4, 16.4a that was recently added actually, 16.5 also that was recently added with regard to EWS. okay. And then you will write that how this protective discrimination have been limited. okay. So it cannot be for everything. okay. So it have been limited, like for an example with regard to see this Mandal Commission case basically affirmed protective discrimination, but put a limit to it, right? So that limit you can write. okay. Extent of reservation, right? okay. You discriminate, but you cannot discriminate more than 50%, especially with regard to equality of opportunity in the case of public employment under article 16, right? So those limits you can write. The concept of criminal layer that was established, that is also the limit on protective discrimination. okay. Right? Similarly women and children, that you may skip, not much needed, but this is the case which actually led for that. okay. That I have given here also. See, constitutional validity of 16.4a, that such reservation policy will satisfy the following 3 conditions. okay. So these are the 3 conditions. Now one important 2 and this 3. SC community should be socially and educationally backward. Community must not be adequately represented in the public employment, and that shall not affect the efficiency of administration that we have in 336. okay. Article 336, right? So those sort of stuff then that was told. So you can write this case also, right? And then you can conclude that in a country like India, and this protective reservation is actually justified. okay. actually it is justified. Okay, so again it is a 20 marker question, that is why you have to write a lot. Okay, so see again, explain the doctrine, then go for the constitutional provision, and then the scope of the protective discrimination, limitations upon it. Okay, and then interrelationship between 15 and 16, and their sub clauses, right? Their sub clauses, and then a very general conclusion that yes, in India we do need protective discrimination. Okay, understood that particular point, right? Now if you want, you can write 1 or 2 questions and send me, but I do not guarantee that I will check it. Okay, if I will have time, I will check it, but I cannot guarantee you to check it. Okay, yes. Now let us come to second question of the discussion today. Can amendment of the Constitution of India for better union-state relationship is due? Now you might find a lot of this question, right, where your opinion is asked. Okay, and that is one of it. Comment on the statement and substantiate your recommendation for the amendment of a specific provision of the Constitution. Right, now it means that you have to agree that this condition exists. It is due. The question assumes that it is due. You have to simply substantiate, and you have to recommend that, okay, what are those provisions that you think should be suitably amended for the purpose of having a better relationship between union and states. Right, so it is not talking about different organ of the government, but different layer of government. Okay, it means how the cooperative federalism should increase, right? The last question, part 2, you must have seen, right? The question with regard to cooperative federalism, right? So how the cooperative federalism should be increased, that is the main issue, if you think. Now you first talk about the nature of union and central relationship, right? You talk, right, that how it is supposed to be federal, right, but there is overbearing presence of union, both in the case of legislative and executive domain, right? Now the legislative domain, the presence of a concurrent list says so. Similarly, in the legislative domain, the overbearing presence can be extracted from the presence of the residuary power with the union. Okay, and in the case of executive, right, you might cite all the articles with relation to administrative relationship, right, which says that the executive power, so the state executive power should be such exercised, right, as not to offend the executive power of the union. Right, so it means the executive power of a union will prevail. Okay, or the state have a duty to enforce the law of the union. Okay, so you write constitutional provision and explain that how this nature of the relationship is now, is presently loop-sided. Right, then you write to what is the problem that is exactly happening right now. Right, so there are 2 issues I have pointed out: autonomy in the case of making law, especially in the case of concurrent list, or if there is any conflict, and appointment of governor. That is again due, right? You can add more also here. Also, you can talk about with regard to administrative overhang. Okay, and then you go on the amendment that is required in order to solve those problems. Okay, so very structurally nice answer has to be there. Okay, this is the issue right now, right, and this is the amendment that I am suggesting. Right, so for a state making autonomy, you can talk about the residuary power should be vested in the state. You can say, right, or this concurrent list should be overall deleted. Okay, that amendment you can say. Similarly, with regard to governor, right, that is a very big issue actually with regard to governor, right? So with regard to governor, you can actually write the recommendation of Sarkariya Commission. That is the best way to see that. Okay, and then the administrative power, you can write that the state administrative power should be co-equal to the union administrative power or executive power, right? It should not have an overbearing presence. Okay, and then you can come up with your own suggestions, right? That is your amendments that you have already wrote down that earlier, right? But here you write a very generic sense of that the autonomy should be the autonomy of the state in the matter of legislative and executive power should be restored, or not restored actually, should be maintained, right, by providing a specific provisions in the Constitution, right? So the provisions you have already given earlier, right? But here you write a very generic word of line, right? That what the provision do you think should be restored, very giving it a very generic term rather than writing very specific. A specific you have already written. Got my point? Okay, so I have given the intro part itself, the same thing, right? How legislative overhang is there. So legislative overhang is not there only in the case of the union legislature will prevail, but also in the case of the extent of legislative power, the width of the legislative power, right? Even if you see the list, the topic in the list, it is very large in the case of union and concurrent list. Okay, then need for reform, same instances I have given, right, the examples that I have given, right, and ultimately that recommendations, right, interference by the central institutions, and then talk about the contribution of governors, right, and then you can recommend one of the misuse, you can talk about the emergency provision also, that also needs to be changed, especially in the case of a state emergency. Then dismissal of a state government under state emergency, that is also the issue. And then you can talk about what can be done for the purpose of strengthening the governor's power. Got my point, right? Sarkaria Commission recommendation, you can write it down here. Okay. Similarly, one more thing is there, right? So, interstate council and the role of Rajya Sabha, that also can be written. Okay. I mean, there are a lot of things, right? We have to pick and choose that what are the things you need to write. Okay. Because that was a very generic question, not very specific legal question. Okay. So the scope of answer is very broad. Right? You can pick and choose. I have given here 5-6 topics. You can choose any 2 and 3 and write in the exam. Okay. Because hardly you need to write 200 words, right? Not more than that. 200 words means what? Hardly 25 to 30 lines, not more than that. Okay, now let us come to C, that is your governor's office, right? Why it is sui generis in nature, right? Now this governor's office is sui generis, right? Sui generis means unique, one of its own kind. Like for example, the contempt of court power is referred as sui generis, right? The same thing applies here. Now what do you mean by sui generis? Then the governor in our system does not function as a constitutional head, the whole gamut of his responsibility. There is an important area, though limited and subject to constitutional constraint, which he act in the exercise of discrimination. Examine this statement in the light of Sarkaria Commission, right? So you have to simply cite the recommendation of Sarkaria Commission, very straightforward question. First, write the constitutional provision of governor, why it is unique. See, you must be knowing that all over the democracies in the world, in the state executive, we do not have any person who is appointed by the union. Nowhere. It is only unique to India, and it is a colonial legacy basically. He wanted some white man to control the affairs of state. Right? That is what we wanted. Then little bit you are commenting basically how it is a unique office. Then you provide that there are 2 types of functions that is given to the governor. One is very specific, right, and one is discretionary, right? Now in the case of discretionary functions, the governor plays an important role, right, as an agent of the state, right? And then you write that how this discretionary power have been misused. You can give recent examples, right? And then go on to Sarkaria Commission report to say that how this misuse could be prevented. Understood? So very nicely you can write the structure of this answer, okay, and give proper heading, okay? Sui generis office of the governor, write 4 or 5 lines about it, or 6 lines. Then you write functions of the governor, unique functions of the governor would be more apt. Then you write it is divided into discretionary and specific functions. Then you write discretionary power of the governor, its misuse as a heading. Write the examples, right? What, and then Sarkaria Commission recommendation, right? So very nicely you can sort of write these 3 in a very structural format. I have given the whole detail also, right? See, report of Sarkaria Commission, what should be done. Okay. Now if you remember even 2-3 of them, that will be more than sufficient. Understood that particular point? Okay. Now again, those of you who wants PDF of this PDF, it is freely available on this website. Go and see that. Okay. Done. So that will be all. Thank you.